I want to thank everyone for joining us. And I'm glad you took your time out of your day today to talk about protecting your home and the different options that you have. So today, Kathleen is talking to us again about protecting your home. Kathleen is one of our founding partners of Generations Law Group. She's been an attorney for over 30-ish years. She's also a registered nurse, so she brings those two worlds together nicely. And Kathleen, I would like for you to take it away.
Wonderful. Well, again, thank you all for joining us today. It's so nice to be able to have a chance to see some friendly and faces that we haven't been able to see in person over the past almost year now. So want to talk today really about protecting your primary home. For most of us, this is one of our largest value assets. And it is one of the things that most people are looking to try to protect, particularly in the world of mass health here in Massachusetts or Medicaid planning. So I'm going to really talk about how that works here in Massachusetts. Give me a chance. I'm going to share my screen with you all right now and be able to start our presentation. So again, these are some steps we're going to talk about that can be taken to protect that primary home. We've seen, as most of the country has seen, that primary home values have continued to increase. And so again, we're finding that for many of us, it is a large part of our asset holdings. So let's start with talking about just why plan. And this is more of a question about why plan in general. Certainly planning for the primary home, which we'll talk about today, is critical, but also planning in general is really important for everyone. First of all, it allows you to set your priorities. What's important to you in terms of planning? What's important to you in terms of the legacy after you've passed away? And, those of you who are clients will know that we talk a lot about too, what's important to you while you're still alive. But if for some reason you weren't able to manage your own affairs. And so making sure that you have a well-rounded plan in place is important. It also makes sure that you maintain control. And so, certainly after you've passed away, the idea of maintaining control is a little bit less important. Although what is, I think, critical about that is making sure that what you would like to see happen with your asset holdings is conveyed and clearly understood by your potential beneficiaries. But that idea of maintaining control even while you're still alive, but if you became incompetent or incapacitated for any reason, again, is also critical. And making sure that you have the documents like your powers of attorney and your healthcare related documents, your proxies and your HIPAA authorization and release forms in place are also critical. And then another part of what we see people are concerned about when we talk about planning is the potential of protecting their assets. And this really comes into play when we're looking at potentially paying for long-term care services for someone in the future and how that might work in terms of the protection of assets. But along with that is also balancing, making sure that someone has the ability to keep quality of life, quality of choice, and that their own desires continue to be honored as you age and should you ever get to the point where you're no longer able to handle things for yourself. And one of the things we always remind clients is that when you fail to plan, it can become very costly. Because if you don't put in place these important planning documents, powers of attorney, healthcare related documents, we end up having to get courts involved, et cetera. And that's a place we do not want to go. So let's talk about the home and how we look at planning options when we're dealing with the home. And I'm really going to talk about four main kind of approaches to planning. I need to let you know that there are also other types of planning options, very nuanced planning options, depending on people's individual situations. But these are really the four main planning options that we see utilized. First of all, we're going to talk about what's involved if you give away an asset such as your primary home, and what are the complications, both the pros and the cons of each of these approaches. I'm going to talk to you about a life estate and what a life estate is and how a life estate can help to be able to transfer a property over. I'm also going to talk about irrevocable or irrevocable trusts and how those are utilized in this protection world where we're looking to protect something like your primary home. And we'll discuss a do nothing approach, which is really that you don't go ahead and take advantage of any of these options. And again, what the pros and cons are of that type of approach for you. Well, let's start with the just giving your house away. I oftentimes will get a call from a client and they'll say, you know what, I want to just give my house over to my kids. I've heard that that's a great way of making sure that it's protected and that I don't have to worry about it anymore. I want to just give the value of my house to my children. Now, this also is something that comes up oftentimes with second homes. You know, you have a home on the Cape or up in New Hampshire, something to that effect, and you say, I want to make sure it goes to my kids. This is really the simplest way of moving forward. What it is it's taking the deed and literally rewriting the ownership of the deed, transferring it from you to whoever you want to be the beneficiaries, whether that's one or more, let's say, of your children. It's the least costly way of going. It is really just rewriting a deed and filing that deed with the appropriate registry and making sure now that the children take ownership of the property. But there are some real big downsides of this. First of all, you no longer will own the house. And so the value of that asset, which can be a critical part of the financial picture for your future, being able to use that value, whether you want to take a mortgage or a line of credit against it or a reverse mortgage against it, whether you want to sell it and be able to use the proceeds from the sale on something like a new property or an assisted living situation, or maybe one of the continuing care communities. By giving this property away and just giving it over to your children in this case, you have removed the value of that asset from your use and control. And so you no longer have it for your future desires. Another issue is the control. Again, most of us, if we made the decision to give the house to our children, believe that our children would never, let's say, kick us out of the house in the future. But guess what? They could. They are the owners. And if they chose to no longer want you to be in that home, they then could take steps to remove you as a resident of that property. And so that's something that you do need to think about. The other thing is if we leave that home to multiple owners, so let's say in this example, you have 3 children and you want to leave the house to the 3 children. What happens if the 3 kids no longer agree on things? They're going to be responsible for the taxes on the property, the homeowner's insurance on the property. Sure, they could charge you rent and you could pay for these things to be able to stay in the house. But what happens if in the future they're not able to, upkeep the house, maintain the property? We see this a lot with second homes. You know, it's always wonderful. Mom and dad have bought the beautiful beach house and all the kids come to that house during their lifetime and be able to enjoy it. And the desire is to pass it on to the children so that they can enjoy it. But in doing so, you've got 3 children. Let's say you have one who lives in California, one who lives here in Massachusetts, or even 2 who live here in Massachusetts, but one of them who no longer has financial means. They're not quite as financially set as maybe the other 2. What happens if the one in California no longer wants to own the house? They're not getting out here to enjoy it. What happens if the one who doesn't have the same financial means can no longer afford to pay for their share? So there's lots of complications that come with just giving the house over to the children. There's also a major tax complication that comes when you give the house outright to the next generation, to the children in this case. When you give a house away, you can only give what you have in it from a tax standpoint. And let me explain what that means. It's called basis. And the basis in our property is determined by the value that we bought that property for. And for many of us who have lived in our homes for 20, 30, 40 plus years, that value may have been very low. So let's say you bought your house for $70,000 back in the day. Over the years, let's say you've even put in it about $200,000 in improvements, new roof, new driveway, new heater, a furnace, a new water heater, all of these kinds of things. Maybe you put a new kitchen on the house. Your tax basis would now be $270,000. Now, again, in our area here, we've seen a lot of increase in the value of the properties. So let's say now, if you were to sell your house, it was worth $500,000. You've been able to see $130,000 capital gain improvement on the property. If you sell the property and get that $500,000, you as the owner, the person who has resided and lived in that home, would be able to claim a capital gains exclusion of $250,000. And if you're married, your spouse would also be able to claim that same capital gains exclusion. But when you give the house away to your children, you are giving them your basis in the property. So in our example, you're giving them the house with the $270,000 basis. They then go to sell the property at some point in the future. And again, let's say they sold it for $500,000. And remember, they don't live there. They now live in other places. They no longer get, or they are not able to claim that $250,000 capital gain exclusion. They will have to pay capital gains on that $130,000. So that's another downside when you just give the house away. And finally, there's a 60-month look back here in Massachusetts. That's for Medicaid planning purposes. If you give away assets, such as your house or cash assets, to someone other than your spouse within 60 months of applying for state assistance, such as Mass Health to pay for long-term care, you will be subject to a penalty period for having made that gift. And so the gift of the property has to be done at least 60 months prior to ever needing something like Mass Health coverage to help to pay for things like long-term care services in a nursing home. So it's real simple to give the house away, but there's lots of downsides. You no longer have control. You no longer have benefit of the value. The kids have a potential tax issue that needs to be dealt with when the house is finally sold. They can kick you out. And you have a 60-month look back in terms of this Medicaid planning. So lots of different issues with just giving the kids the house. But let's say you still want to go ahead and give them the house. This is really important to you to be able to protect that value of the home from your potential future needs. One way we can do that is reserve for you what's called a life estate. Now, this is a deed transfer, just like in the first slide in which you're just giving the kids the house. But in this deed transfer, you're transferring it over to the children, but you're retaining for yourself a thing called a life estate. And what a life estate says is that as long as you're alive, you have full use and enjoyment of that property, meaning that you can continue to live in the property, that you will continue to have full enjoyment. The kids can't decide to sell it from underneath you without your agreement. And this makes it so that you're able to continue to preserve your use of that property. Now, again, nothing comes without an upside and downside to it. The downside is that you also have all of the responsibility for the costs associated with the property. So As the life estate holder, you need to continue to pay the taxes associated with the house, the property taxes. You are responsible for maintaining the property insurance on the property, paying the water bill associated with the property. Those things continue to be your responsibility as the owner of the property. Because for tax purposes, you're still considered to be the owner. So it sounds a little bit, counterintuitive. You've given away the property over to your children, but you've retained this life estate, which in the eyes of the IRS means that you still own the property for tax purposes. Now, why do people do this? There's a couple of reasons. Number one, it preserves your rights to be able to live and enjoy that property. So you're able to continue to use the property as you choose, and you continue to be able to maintain control in the sense that no one can sell it without your agreement. For tax purposes, the benefit is really for your children. Talked about that tax basis that is created in your home, what you bought it for, plus what you put improvements on. When you reserve a life estate, the value of the property remains part of your taxable estate. And so when you pass away, that value is still part of your estate for a tax benefits. And when we're looking at particularly the calculation of any estate tax that may be due, that's also known as a death tax here in Massachusetts. And let me give you a quick explanation of that. When an individual in Massachusetts passes away, and their estate is more than $1 million in value. And when we're talking about their estate, we're talking about anything they own individually, half or whatever percentage they own of an asset with someone else, full value of their retirement plans, full value of their life insurance proceeds, and in the case of a property that in which they retained a life estate, the full value of that property on the date of their death is also part of their estate for the estate tax calculation. And when the estate is more than $1 million, then the estate of the individual is now subject to a Massachusetts death tax. That death tax is usually anywhere between about 6 and 16%, with most people coming out at around 10%. So if you have a home that's worth $500,000 on the day that you pass away, you have life insurance policy of $50,000, you have a retirement plan of $350,000, and you have savings of $200,000, you now have a total estate of over $1 million. And there is the potential for the estate tax to be levied. And because we're Massachusetts, we aren't an exemption state. We are a threshold state. So the moment you hit $1 million in value, everything in your estate is subject to that estate tax calculation. So, you have about a $1.2 million estate in value. Your beneficiaries, or excuse me, it's actually your estate before your beneficiaries get the value, will get hit with about $120,000 in an estate tax. So keeping the life estate in the property makes it so that the value of the property is part of that estate tax calculation. But here's the benefit to your beneficiaries. Your estate will get hit with the tax, but the beneficiaries will receive the property at whatever it was worth when you died, not at your tax basis. So remember we talked about the property and we said you had a property that you bought for $70,000, you put $200,000 into it over all the years that you had lived in it. Your tax basis is now $270,000. If you give that property to your children but keep a life estate, And when you pass away, the property is now worth $500,000. The children will get it at the $500,000 level, not the $270,000 level. And that means that if they go ahead and sell it fairly soon after your passing, they're going to have little or no capital gains to have to pay. So it really saves the children that capital gains concern after your death. The estate may have an estate tax issue, but the kids won't have to deal with a capital gains issue. So a life estate makes it so that you still get to use and enjoy the property. It keeps the value of the property as part of your estate, but it allows the children to receive the step up in basis upon your death and help to reduce their estate tax exposure. Now, a few more downsides to think about when you're, again, thinking about whether this is the right way to pass on property to your beneficiaries. When you give them the property, even though you've retained this life estate, they still have an ownership interest in the property because you've given up everything else to them. So you can't sell the property without their agreeing. You have to have them agree and you have to agree. And potentially that value of the property that they've received, even while you're still alive, is subject to their lives, meaning that if they went bankrupt, this is one of their assets that they own. They may not be able to force its sale, but there could be a lien placed against the property. You may have difficulty pulling value out yourself. So if you wanted to get a mortgage on the property or a home equity line on the property, that could be an issue depending on the lender. It used to be that you couldn't get a reverse mortgage as a life estate holder, although there are some companies now that will give a reverse mortgage on a life estate interest in a property. But you do have to be careful because that property is going to be subject to the lives of what we call the remainder men. That's what we call your children in this situation. And if they, again, get sued, they get divorced, they go bankrupt, those kinds of things, this property is potentially an asset for them as well. And then the gift of the property to them still is subject to the 60-month look back. And so that's critical to remember in terms of planning. One really big issue that we have with life estates is they can work really well if you're going to continue to hold on to this property and live in this property until the date of your death. Because again, you retain the full control while you're alive, and the kids get that wonderful step up in basis when you pass away. But if you choose to sell the property while you're still alive, let's say you go ahead and you do a life estate transfer, and 6 years, 7 years later, you say, you know what, this isn't working for me living in this house anymore. I really want to sell it. I really want to move somewhere else. Now, remember, you're only a life estate holder. You need to get everyone to agree to sell, but let's say they do. Kids say, of course, mom and dad, we want to sell the house if you want to sell the house. You can get a capital gains exclusion for your portion. And how we determine your portion is there's these life estate tables that the IRS puts out that says based on your age at this time, this is the percentage of ownership that your life estate equals. And this is the percentage of ownership that goes to your children as the remaindermen. As you get older, your percentage drops down. So maybe at 65, if you gave the house to the kids, your percentage of ownership was somewhere around 60%, and the kids had 40%. As you get older, and let's say you're now 85, your percent of ownership may drop down to 15%, and the kids will own the other 85%. And so if you sold the house while you were alive, while you were 85, you would only get 15% of the proceeds from that sale. The other 85% is going to go to your children. Now, you could get a capital gains exclusion because you lived in the property. They can't if they are not living in the property and meeting the IRS requirements for ownership and occupancy. So you've sold the house while you're still alive, you're going to get a lower percentage of the proceeds because of your life estate ownership. The kids are going to get the other percentage and most likely going to be subject to capital gains. Where if they hang on to it and you hang on to the house until the date of your death, that capital gains is no longer an issue. That's a lot of information. I hope that made sense to you all regarding life estates. The takeaway is really that it can be a good way in some circumstances to pass a property on to beneficiaries, but you really have to be sure that you're going to stay in that property until date of death in order to get the full benefits that we're talking about.
We have a question, Kathleen,
Sure.
that says, please explain the role of the 1 million exemption and life estate.
So that's what I was talking about, that the benefit of the life estate is the tax step-up basis for the kids, but the value, the full value of the property is part of your estate tax calculation. So if you're an individual, and we use this example of your property being worth $500,000, when you die, that $500,000 value is part of the $1 million that you can have up to before your estate is subject to an estate tax. Does that make sense?
I think so. Thank you.
So, you're welcome. So let's talk about another way that we do it, because one of the other complications, and I talked about it in the first one too, is if you are leaving an asset to multiple beneficiaries, that can oftentimes be a source of conflict. What happens if all of the kids don't agree on what to do with the property and how to handle things? So then there's a hybrid approach that we oftentimes will use. And this is where we reserve a life estate still in the property, but we, instead of giving the property outright to the beneficiaries, we put it in an irrevocable or irrevocable trust. So let me tell you a little bit about irrevocable trusts. Think of them as sealed boxes. The purpose of that trust is to protect whatever asset or assets you have put into it. And we're protecting them from your future needs. We're trying to make sure that the value of that asset is not exposed to your future costs, expenses, particularly long-term care expenses. So one of the things that we can do is take the house, put it into the irrevocable trust, and the irrevocable trust benefits your children. And in the example that I've been using, let's say you have 3 children. You make one of your children the trustee of the trust. So they're responsible for managing things and being able to make sure that the trust terms are followed. But you make all 3 of the children the beneficiaries. So certainly after your passing, the children are able to access the value that's in that irrevocable trust. But we also write the trust in such a way that while you're alive still, the trustee, who again in this example is one of your children, they are able to access the value of the trust even while you're alive. Not for your benefit, you can never be the beneficiary of the trust, but for the benefit of themselves and their siblings. And so what we do is we take the house and we put it into the irrevocable trust. So instead of deeding it over to the 3 children directly, we deed it to the trust. But we retained for you that life estate, because remember, that life estate gives you some benefits. It makes sure that you still are the one who can use and enjoy the property. They can't sell the property without your agreement. It does keep the value of the property as part of your estate for the estate tax calculation, but it also gives the children that step up in basis when you die. And the benefit of it being in the irrevocable trust instead of out to the kids directly is that you have it being controlled in one place. So let's say you decide in the future that whole idea of sale of the property. You don't want to live in the property anymore. It's just too much to handle. You're not going to keep it until you pass away. There may still be some tax consequences, as I talked about. You can get the capital gains exclusion, but the trust in this situation cannot. But now there's a pool holding the proceeds. And so if a tax has to be paid, it can be paid out of that pool of money and not individually by the children having that tax liability. Also, you could say, let's sell the house. And then because the proceeds are held in that trust as a pool, the trust could help to buy another house for you if that was the choice. And you would continue to be protecting that value as you go forward. Where if it were with the 3 children individually, each one of them would have to agree to go ahead and sell and go ahead and buy something new for your benefit. And so having the trust as the way of being able to hold that remainder value in the property gives you one controller, the trustee. They're the one you have to deal with really in order to be able to make any potential changes or some kind of option of being able to move forward for yourself while still protecting that remainder value should you need to go into a nursing home. Couple of things to know again. We do have the capital gains issue if the property is sold while you're alive. We also have the 60-month or 5-year look back. But it does allow us, particularly when we have multiple potential beneficiaries, a central way of being able to control things instead of having to always deal with those multiple beneficiaries. So setting up the property into an irrevocable trust, but retaining a life estate for yourself is a way of being able to continue to manage the property by one person instead of having to deal with the multiple beneficiaries on any future decisions. You still get the protection after you go through the 60 months, and you still get the step up in basis as long as you hang on to the property until you pass away for your kids. And so utilizing that is another option. Then I want to talk about the do nothing option. So again, oftentimes, our homes really are a large portion of our portfolios in terms of value. The other thing is the house isn't the same in terms of looking at your portfolio. It's not like an investment account in terms of the ease of being able to get the value out of the house. It's where you live. It's probably where you've lived for a long time. There's emotional attachments to a house and all of that. The house also can be used when we do nothing as a way of being able to pull value out for you if we needed to get a mortgage or a line of credit. Again, if you needed to use something like a reverse mortgage, you can use the value of that house oftentimes to support your other needs. You become ill, you need additional care, and you want to stay at home. That value in the house can really be used to be able to help support you in what your desires are and what your wishes are for your own future. When we have a house and we have a couple, a married couple, and one of them needs long-term care services in the future, whether it be services at home to help meet their needs, or services in a long-term care facility, there's a lot we can do to protect the value of the house by just transferring it over to the healthier of the two. And we can then move forward to get benefit for the ill spouse, the one who needs additional services. There are some limits, for instance, and I apologize, I believe this number is a little bit outdated. I think we're up to 880,000 in equity value now. The house has to have less than 880,000 of equity value to allow us to protect it in this way. But it does give us a lot more flexibility. We're not having to give away this asset. We're able to keep it within the couple, even though we do need to transfer it over to the healthier of the two. And we can get benefit, whether it be an at-home benefit or whether it is in skilled nursing facility benefit for the sicker of the two of them. And so it's a way of keeping full control, full access, and full ability to be able to make future decisions with either the individual or the couple. And so doing nothing, I don't mean doing nothing by not thinking about anything to do. You always want to think about the planning, but by not transferring it away and putting it in some place in which the value is locked away from your use and control is a viable option for many people, depending on their individual situations. There's another thing that I didn't talk about specifically in the slide, but when we have an individual who has a long-term care policy, when that long-term care policy meets certain requirements, and typically those requirements are a minimum daily value, that's usually around 125,000 that it meets, as well as being able to pay out benefits for at least 2 years, then that policy can also be a way of protecting the primary residence from what we call a mass health lien. And let me explain that a little bit. So let's say you are living at home and something happens and you need to go into a skilled nursing facility for care. You need nursing home care. You want to protect the value of your property from mass health putting a lien against it while still being able to be eligible for mass health services. Now, most people know that you can't have more than $2,000 in assets in order to be able to get mass health benefits here in Massachusetts. But you are able to own a primary home. It is not true that you have to sell the home. What happens is, in most circumstances, if someone has to go into a nursing home facility, but they own a primary home, Mass Health will give them benefit as long as they meet all the other criteria, but they'll put a lien on the primary home. And so when the primary home is eventually sold, that lien needs to be satisfied. And that satisfaction will come out of the sale of the property. When you have a long-term care policy that meets certain criteria, Mass Health will still give you benefit as long as you meet all the other eligibility requirements, but they'll allow you to keep the primary home and not put a lien on the property. And so it's an interesting benefit when you are able to qualify for long-term care services, and you do have a qualifying policy in place that can be used to help protect that value. So again, when you're thinking about what to do with your home, some things to consider: what's your comfort level with control? Who's going to have the control? Is it something that you feel comfortable giving up and having confidence that the people you give it up to will do the right thing? What level of control do you want to keep on it? Do you need the value of that property for yourself? Whether it be by desire, just because you say, you know what, I want to be able to use this value. It's my home. If I need it for myself in the future, I want to be able to take it. Or is it that you need that value to be able to provide for your wishes in the future, your care needs in the future, that kind of thing? Do you ever think you'd want to use something like a reverse mortgage or a line of credit on your property to be able to help to pay for either services you need or choices that you may have in your future life? And then considering all the tax consequences that we talked about, we always have to look at those and consider them for each person's individual situations.
Kathleen, we have a couple questions.
Sure.
Going back to your previous slide and topic, someone asked, is there the same limit of 880,000 in this case where you have a long-term care policy?
Do you still have, yes, because the 880,000 is related to mass health benefit. And so there is still that issue. If someone's home has more than 880,000 of equity value, one of the things that we can look at is whether you should take a line of credit in order to bring the equity value below that 880,000 so that you then can get on benefit.
Okay. And then the other question is, do heirs have to pay capital gains under DoNothing? Also, is the value of the house part of the 1 million exclusion?
So the heirs will not have to pay capital gains because they don't get the value of the property until your passing. And so they'll get it with that step up in basis. Their capital gains will only come into play when we take the difference between the value on the date of your death and when they sell it. So if they hang on to it for a long period of time, they may be subject to capital gains. But if they sell it fairly quickly after the date of death, that capital gains will be significantly reduced, if at all. And then, is it part of your estate for the estate tax calculation? Yes. And so with the DoNothing approach, that value will be. Now, remember that $1 million value, I talked about it really for an individual. When we have a married couple, it's a very different scenario. We don't typically have an estate tax that is levied when the first of a married couple passes away. It is usually only when the second of the married couple passes away.
Thank you.
So a couple of other things that I wanted to talk with people about when we make these kinds of decisions about what to do with the primary property. And I know Carol had sent out a couple of articles that were very interesting from the Boston Globe. One is that there are a lot of different tax relief programs that may be available, not only from the state, but by your own local governments, your own town governments. And, you know, things like tax abatements and deferrals, excuse me, and reasons why taxes are sometimes reduced, property taxes. These tax relief programs, if you make a change in the ownership of your property, may be affected. And so we always want to look at the different tax relief programs that you may be taking advantage of and whether a change in the property ownership is going to remove that tax advantage for you. And so there's a great article about you're over 65. Here's one of the best kept secrets in Massachusetts. And it's talking a lot about some of the different municipality benefits that may be out there for you. Another one that we know that Carol provided you some information on is an article called An Inheritance Damaged by Delayed Property Taxes. So this is a situation in which the senior had taken advantage of property tax deferral programs. And these were programs offered by their town that said you can defer the payment of your taxes until the time in which the property is sold or otherwise transferred. And it was a wonderful program for the senior who was living there because they didn't have the expense of property taxes. And as most of us know, property taxes can be a huge amount here in Massachusetts on our primary homes. But what they didn't think about is that that deferral comes with a cost. Not only does that bill have to be paid at some point in the future when that property is sold or transferred, but typically that deferral also occurs at an interest rate. And so what was a small amount of deferral, relatively speaking, because it had gone on for such a long period of time, had now had a substantial interest rate also added to it. And the beneficiaries who thought they were receiving this property without any liens or encumbrances because there was no mortgage, anything like that on it, found out very quickly that there was a large tax bill that was due and owing, and that tax bill had run up a huge interest as well. And so again, when you're thinking about taking advantage of protecting your primary home, you need to really look at this comprehensively to determine what kinds of impact it may be having on other benefits you might be receiving now, and what that impact will translate to your beneficiaries in the future. So again, talked about the Boston Globe articles, talked about the effects of the reverse mortgage. Let me talk to you a little bit about reverse mortgages as well. Reverse mortgages can be a great way of being able to utilize the value of your primary home for your benefit, to be able to pay for things that you might need, to keep you in your home for a longer period of time. But they do come with cost, and you have to understand that. Typically, a reverse mortgage will give you about 65% of the value of the property. And a reverse mortgage isn't where you sign the property over to someone else. It's a mortgage, just like any other mortgage. But the difference is that this mortgage is not one that you pay back in real time. It continues to accrue, very much like the deferral of taxes that I just talked about, and becomes due and owing when the property is sold. You have to be very careful though, because you as the senior who have taken out the reverse mortgage have to continue to live in the property. If you can no longer live in the property, then that reverse mortgage will become due and owing. And there are, again, costs that are associated that oftentimes get tacked on the end. And so even though it's only about 65% of the value that you take out of the property, it can be that the cost of getting the reverse mortgage and the accrued interest on that payment can take up a much larger percentage of the value of the property, and even up to 100%. One thing to know though about reverse mortgages is it can't go over the 100%. So it's not like if the value of the property for some reason were to drop, if we were to see a huge crash in terms of our market values here, the reverse mortgage can't go into your estate to pick the shortfall. It is the property and only the property that secures that reverse mortgage. So they can be a great planning tool for the right person, for someone who really needs to pull the value of their property to continue to stay in their home and get the care and quality of life that they want. But there are costs associated with them, and you have to understand the ultimate impact of that. So that's really it. I want to remind everybody, planning should always be all encompassing. It's not just a look at one thing. We really want to look at everything as you're moving forward to see how the pieces fit together, to make sure that your wishes are followed, that they're clearly understood, that you've put in important decision makers into place so that if you can't make decisions for yourself, these people are ready to go and willing and able. And that your wishes are clearly outlined so that even after your passing, what you want to see happen is clearly stated and being able to be followed. I hope that was helpful, everybody. Again, dealing with your primary property in particular, lots of options about how you can look to protect it, but you really do want to look at all of those different options to determine what's right for you.
Yes, I had a question for Kathleen. Kathleen, we hear the advertisement on the radio often, save your home from the nursing home. And you've gone through different approaches, but essentially the people who sign up for that solution, what are they really signing up for when the advertisement says, save your home from the nursing home?
So typically that's the use of the irrevocable trust. And I always try to tell people, I can protect all of your assets from the nursing home. We can take all of your assets and put them into an irrevocable trust and lock them away. But the thing that you have to understand is that we are locking them away. And so you lose a lot of control, a lot of access to those assets in the future. And so typically what we see with those advertisements is it's the use of an irrevocable trust. And irrevocable trust can be a great planning tool when they're used appropriately. So when you are balancing the approach that you're taking, maybe you want to protect a certain amount of assets or value, but we always want to make sure that you continue to have enough assets under your own control, in your own sphere of influence, so that you continue to have quality of life and quality of choice. I always try to tell clients, I think it's wonderful that people want to take care of their children, their loved ones, their charitable, endeavors, all of these kinds of things. But your primary responsibility is to yourself and to a spouse, if you're married, to make sure that you can live the life that you want to, that you have choice, that you have options, and that you have quality. And so these types of trusts are absolutely wonderful tools when they're used as part of an overall plan. And you're really thinking about, how do I balance this approach?
Thank you.
I thought I saw a question about irrevocable trusts. Are there any advantages to a grantor trust in this situation? Yes, so irrevocable trusts can be written in many different ways. When they are written as what's called a grantor's trust, they retain the tax benefits very much like the life estate that I talked about. The grantor, this is typically the senior who has created the trust and put assets into the trust. Those assets still are part of the grantor's estate for estate tax purposes. And so when they die, again, here in Massachusetts, that $1 million exemption comes into play, or threshold, and the value of what they've put into that grantor's trust is part of the estate tax calculation. The advantage is to the beneficiaries because they get a step up in basis for whatever asset was put into that grantor's trust. If it's the house, then the house is stepped up to whatever the value is when the person dies. When it's securities, stocks, other investments, the value is stepped up to whatever the date of death value is. And so it can be a great way to pass on assets to beneficiaries with a higher tax basis, reducing their capital gains exposure. The other way we can write an irrevocable trust is as a non-grantor trust. This is when we want to take the value of that asset and take it out of the grantor's estate. So if we use that for a house, we take that $500,000 value and we've now removed it from the estate tax calculation. That's great for the estate tax liability. But because we've removed it from the estate tax liability, we now have made it so that the recipients are only getting the lower tax basis. And when they go to sell it or somehow do something with that asset in the future, they have a potential capital gains concern. Uncle Sam's going to get his taxes one way or the other. He's either going to get it from your estate, or he's going to get it from the trust, or he's going to get it somewhere. It's a matter of looking to see what's the best way of doing that.
All right. Well, thank you, Kathleen. I think that's all the questions for today.
Thank you. I appreciate everyone being willing to come. Thanks again. Stay healthy, be well.